Okay, everyone. I think we'll kick off there. We have a lot of participants, which looks wonderful. So let's begin. Good morning to everybody who's just joined, and welcome to the Quadrant Chambers International Arbitration Seminar 2020. Today's session is about Res Judicata. It's entitled One Contract, Two Arbitrations. Res Judicata is a tricky topic in international arbitration, but we encounter it frequently in one form or another, and it has the potential to complicate and derail proceedings when it does come up. At its core is the interest that all parties have in ensuring that the same claim is not heard between the same parties twice once it has been decided. That's an interest that is in principle common to all disputes, whether common law, civil law, or even international law, or any other system of law, and whether in litigation or in arbitration. However, in international arbitration, difficulty arises when you try to drill down in any given case on precisely what has been decided and what can be revisited. The multiplicity of governing laws that have a bearing on res judicata give rise to complexities that tribunals need to resolve as part of their mandate. Now, questions of res judicata commonly arise in long-term legal relationships. These can take many forms, including international projects, natural resource concessions, partnerships, shareholder agreements, and various other long-term investments. But unfortunately, the private and confidential nature of arbitration means that judicial guidance in the way of awards is thin on the ground. So we're lucky today to be joined by three esteemed panelists who have kindly offered to share their insights based on their experience of these issues in practice. Now, we're joined by Jessica Gladstone, who is a partner and solicitor advocate in the International Arbitration Group at Clifford. She specializes in arbitration, commercial and public law litigation, and public international law, and is widely recognized in the legal directories as one of the brightest talents of her generation. And she advises on international trade and investment, immunities, economic sanctions, and human rights. And earlier in her career was a senior lawyer at the UK Foreign and Commonwealth Office. We also have Ed Poulton on the panel, and Ed is a hugely experienced partner in Baker McKenzie's dispute resolution team, where he chairs the firm's International Arbitration Global Steering Committee. Ed's practice covers a wide range of industries and sectors and regularly sees him acting in multi-billion-dollar commercial and investment treaty arbitrations, as well as sitting as an arbitrator. In addition, Ed frequently acts in disputes in the English Commercial Court. And last but certainly not least, we have Simon Rainey QC. And Simon is a colleague of mine at Quadrant, who has a stellar reputation as a heavyweight commercial silk. He is the Legal 500's 2020 International Arbitration QC of the Year and has appeared as leading counsel in disputes administered by all the major arbitral institutions around the world. And he also sits as an arbitrator. In addition to his arbitration practice, Simon frequently appears in the senior courts in London, including the Supreme Court, where he has been brought in to argue 6 appeals in the last 3 years alone. So that's your panel. Now let's hear from them on today's topic. And Jessica, perhaps I could start with you. I wonder if you could give us a sense of the legal situation that we're concerned with when we talk about res judicata in international arbitration proceedings.
Sure, thanks, Gaurav. So the fundamental principle, as you outlined, is that once a legal right or obligation or a point of fact specifically put in issue has been determined by a competent court or tribunal, the idea is it cannot be put back into question as between the same parties. So the matter will be conclusive for subsequent proceedings that pass the triple identity test. So that is where there is the same subject matter, the same cause of action, and the same parties. And there are very good policy reasons for this rule. It obviously prevents individuals having to repeatedly refight the same battle and avoids the considerable uncertainty or inconsistency and inefficiency that would result if the parties were entitled to keep raising the same issue again and again. Now, res judicata as a general principle is well established in both common law and civil law systems. But despite the ILA recommending almost 15 years ago the adoption of a transnational approach to res judicata in arbitration, there's no universally accepted approach across jurisdictions, which of course causes a problem for arbitration. In some jurisdictions, it is only the operative part of the award, the dispositif, that is res judicata. But in other jurisdictions, the principle can apply to other parts of the award, such as the reasoning behind the decisions, And the former approach is more common typically in civil law jurisdictions, with common law systems perhaps more often taking the broader approach. And of course, as tribunals often have arbitrators from different juridical traditions, instincts may vary as to the strictness of approach, and decisions may vary considerably depending on the laws being applied in any given case.
Ed, I'll bring you in here. What contexts have you seen this issue come up?
So, I mean, I think as you said in your introduction, it tends to come up more frequently, or at least I've seen it come up more frequently in long-term contracts. So contracts between the same parties for a long duration, where there is the real risk that there will be disputes on issues that have arisen in the past. So you mentioned major projects. Another type of situation where these types of issues arise quite frequently are gas pricing arbitrations, and where the same provision will come up, but there may have been some change in the circumstances, and then there is some uncertainty as to which aspect of the decision may be res judicata or not. And as Jessica rightly pointed out, that can depend to a great extent to who's looking at it and through what lens. And we'll talk, I know, as we go through about what law you should apply to that question, which is obviously of primary importance. An interesting situation I had over the last couple of years, actually, which I hadn't encountered before, where issues of res judicata came up, was in the same arbitration between the same parties, where we had unfortunately lost and challenged under Section 68 certain aspects of the award, which were set aside for serious irregularity. And therefore, certain paragraphs of the award and certain issues were remitted to the same arbitrator. It was a sole arbitrator in this case. And we ended up effectively, because time had moved on and it was impossible to determine the issues that had to be redetermined without going into some of the facts again. And it was a real challenge for the tribunal, but also for the parties when they were being asked which aspects of the issue were res judicata and therefore not open to being reconsidered. And that adds a certain layer of difficulty, because there were certain aspects of his previous decision that he was bound by, even though with hindsight, in order to get to where he might have wanted to go, he might have liked to be able to revisit those and wasn't able to. So that's a sort of practical example of where it came up in situations that are slightly unusual.
Yeah, I mean, I think the long-term contract point is a very good point that Ed makes. But another situation, in my experience, one really pregnant with difficulty, is that of rulings in the same arbitration by the same tribunal at different stages in the arbitration. Let's take three examples. One, a simple bifurcated hearing, liability quantum. Another, more complicated, multiple stages in a long-running arbitration with sets of issues being determined, with overlap between points of construction and points of fact being run. And thirdly, preliminary issue hearings in an arbitration which will not be decided completely by the preliminary issue. And that last one is quite interesting, because I was involved in a recent case where that came up, and where res judicata was addressed by the court in principle. It's DSME and Songa Offshore decided earlier this year. And the facts are really quite extraordinary. It was an arbitration, international commercial arbitration. DSME as claimant alleged that we were responsible for certain design defects in the rig, all turned on the meaning of one particular clause. So DSME said, well, we want a preliminary issue on that because it's a critical provision, and we have no other claims. So that was the selling point for the preliminary issue. Give us the preliminary issue, it's the end of our claims against you, notwithstanding that we had counterclaims against them. Anyway, perhaps first thoughts or worse thoughts, they lost on the point of construction, they lost on Section 69. A month later, an application to amend to run a completely new case based on precisely the same facts, but a new legal case. And it was a legal case that could have been run as an alternative to their primary argument. We said, abuse of process res judicata, you should have brought that forward at the first stage. You've effectively been precluded from bringing it forward now by the award. outrage from the SME, who said you can't possibly have res judicata in that situation. This is just an amendment in a continuing arbitration. How do we deal with your defence to the counterclaim? International Arbitration Tribunal, res judicata upheld. You can't advance any new claim, and you can't defend the counterclaim on any of the matters you could have relied upon. Off it goes to the TCC, and unusually we had a full hearing of the Section 69 application for permission, and not unusually they did a Section 69 and a Section 68, because everybody does, and they lost. Interestingly, the case law is very divided. A lot of people, some judges have said that you shouldn't actually have res judicata in an amendment context. Let it be dealt with by ordinary amendment principles. Other courts have said, well, that's wrong for the reasons that Jessica's given. It's entirely productive of duplication, and you must bring forward your points. Mrs. Justice Jefford, in a really detailed judgment, went through all the cases and found that it is, res judicata does apply in procedural rulings like that, but it should only be rare and unusual, and this was a rare and unusual case. But it highlights, I think, in an interesting way, the dangers, particularly of Henderson and Henderson issue estoppel. Not the cause of action type, but the type that if you don't bring it forward, you lose it, the use it or lose it estoppel. And I think that's a real problem in the situation that Ed's been talking about, and in the same stages in the arbitration, particularly at the bifurcation stage.
Yeah, I can imagine. Actually, I'm sure a lot of people have read overnight there was a judgment in the Delaware court between E&I and Gulf LNG, which relates to a collateral attack. And so you can see subsequent proceedings or efforts made to attack the same decision arise a lot, whether it's the same arbitration, as you say, Simon, that kind of example, or new arbitrations in relation to the same decision that's already been taken. So it comes up an awful lot.
Yeah,
I think, doesn't it? Ed, a few minutes ago, you spoke about the laws that come into play when dealing with res judicata. Can you expand on that a little? How does that work? It's very complicated, isn't it?
It is complicated, and as Jessica said, there's no established principle in international arbitration, and so there's little guidance out there. There's, as you said in your introduction, not a huge amount out there publicly available to see how tribunals approach these questions. And so I've carried out, as you'd expect, quite a bit of research in preparation for today, and also need to thank all the people who did a lot more research that I was able to delve into for the purposes of this chat. And there seem to be broadly three types of approaches that tribunals have taken. And I'm talking here about tribunals. Obviously, this also comes up in court proceedings related to arbitration quite frequently, not just in the circumstances that Simon just described, but also on enforcement cases. And there are quite a few cases, particularly coming out of Switzerland, actually, and Sweden, that we could talk about at length if we had time. But I'm going to try and summarize the three options and then tell you which one seems to be the most popular. And hopefully Simon and Jessica will agree, but if they don't, it'll be much more entertaining. The first of the three is the law of the seat of the arbitration in which the question is being determined. And actually, I'm going to cut to it. This is by far, I think, the most adopted and recognized of the approaches. And this is effectively founded on the principle that questions of res judicata are procedural or evidentiary in nature rather than substantive. And as such, the law of the seat should apply to the question of whether the matter before that tribunal is res judicata. And this is very consistent with the approach that English, US, Swedish, and Swiss courts have taken when looking at these own questions. And they tend, when they're looking at the question of res judicata, to apply their own domestic rules at that stage. The second option, and this is probably the least prevalent, it is you apply the law of the seat of the first arbitration. So the arbitration that people are saying creates the res judicata in the first place. And the reason for that is the flip side of that, which is any award or judgment should only have the impact on the parties that they would have expected it to have under the procedural law of that dispute. And then the third one is another law, and generally that tends to be the substantive law of the dispute. And there are different reasons. So some commentators and courts and tribunals have decided that actually it's more of a substantive rather than purely procedural question, or have said that the way in which the choice of law clause in the contract in question was drafted so broadly or in such a way as to encapsulate principles, for example, of res judicata. And you can see that in that case, they would be relying on the principle that is not only familiar, but very dear to all arbitration practitioners of the party's choice trumping all. So in summary, and I've probably gone on too long on this, but the prevailing view, but again, it remains pretty fact specific, is that the tribunal should apply the procedural law, i.e. the law in the seat where they are sitting when they decide this question.
Yeah, I think I agree with Ed that, I mean, in my experience, it's usually the seat. I have come across will carry it forward from the first arbitration, which actually does avoid the sort of problems that one gets with a seat choice. I mean, I've been involved in an arbitration, I'll disguise the facts a little bit because it is still live, where the venue problems could have been really quite acute in res judicata for the reasons that Jessica gives. Arbitration clause in a long-term gas contract. Claim number one is made for breach for a particular period, the first 10 years. That is dealt with. The arbitration clause was very unfortunate because it allowed the parties to select the venue for each dispute, a recipe for disaster rather than fixing the venue for all disputes. So what happens is the first claim was brought, venue, although the hearing took place in The Hague, venue London. Liability is therefore determined in a liability award, and then there's a second stage in London for quantum hearing, bifurcation. The London tribunal decide various matters, both in the dispositif of the award, but also, as usual, in long discursive reasons. Second claim brought for the next period before a new tribunal, seat Geneva, arbitration taking place in Paris, 2 French arbitrators, 1 German arbitrator. The first arbitration tribunal, the London tribunal, held that a notice didn't need to be given in the context of starting the arbitration. They construed a particular clause. The same clause covered the question of rights to contractual termination. And the termination was the issue in the second arbitration. So it was argued by the one party, well, you can't rely upon the fact we never gave notice because the first arbitration tribunal held we didn't need to. To which we responded, well, that doesn't really apply because it's a different context. And there, the res judicata was relied upon, but the res judicata completely changed from English arbitration, which would have been able to look at the reasons and look at the reasons that led to the decision, to Swiss law, which is even stricter than most of the law countries, which looks only at the dispositif. That is the sole thing that gives l'autorité de la chose jugée, not the reasons unless the reasons are actually expressed in the dispositif. And then the French arbitration, our French arbitrators are plainly a bit unhappy with that Swiss law position because French law is moving towards well, yes, dispositif, but some reasons for the dispositif. So luckily it all went off on other issues, but it could have been a complete nightmare for just the reasons that Jessica gives. Different venue, different arbitrators who are applying the law. It should be civilian, but it's slightly different because they've got a French mindset to the Swiss problem. And it does make you wonder, whatever happened to the ILA recommendations of 2006? Wouldn't there be a better solution to all this? But that's how it is.
Well, Simon, on that point about how tribunals deal with this issue more generally, I suppose that opens up another can of worms altogether, doesn't it? How do you deal with this? Do you just wait until the end of the arbitration and decide everything together? Or is there it seems to me that you probably need to understand what the playing field is as you go along. So maybe there's a different way that a tribunal needs to handle a situation where res judicata or earlier decisions are pleaded.
Yeah, well, it depends when you're handling it. If you're handling when it comes up and you get presented with the res judicata argument, then you've got to deal with it. I mean, I normally my default option is usually to apply the law of the seat. But since the experience I've just been talking about, I have just made an order in a bifurcation case, and I have actually asked the parties to consider what steps need to be taken to protect any res judicata being carried forward, and have the parties actually addressed it, because you can then get some real horror stories where the quantum hearing is completely sidetracked by what's happened in the liability hearing, and no one thought about it. Completely unthought of a res judicata, which potentially blocks you off from important arguments at the quantum stage.
Yeah, I can see that. And Jessica, maybe I can bring you back in here. You mentioned the triple identity test earlier, and it made me think of the Halliburton and Chubb case, where you have different proceedings between different parties. So maybe some other practical issues. What other practical issues arise when it comes to these questions and the parties involved?
It's interesting, and the Halliburton case is a really interesting one. There's only it's a different scenario. It's not res judicata in play, but there you have one party in common, but the same factual scenario and two similar insurance policies, and critically a common arbitrator. And so while res judicata is not there because you don't have a commonality of the parties, only the respondent, in fact, even knew about the other arbitration at all. But the practical reality is that the common arbitrator is unlikely to reach inconsistent decisions on the very similar scenario and insurance policies. And the issue is essentially that a party could, without the other party's knowledge, benefit from an effective issue estoppel, issue conflict, on a matter that has already been finally determined elsewhere by one of the arbitrators. And that case has been heard in the Supreme Court, and judgment will presumably come sometime soon. So it's a really, really interesting one to watch for. There are other examples as well around the question of commonality of parties and the identity of the same parties. And a practical issue that I've seen arise recently is where some, but not all, of the parties are common across the disputes.
There's some interesting old cases on wills where the court has decided the meaning of a particular will in relation to a particular bequest. And then another beneficiary comes up and has the same clause to be construed, but in relation to a different bequest. And there's an Australian case where the Supreme Court of Australia split, High Court of Australia split, but the majority held that there was a res judicata, and the English cases tend to follow the rule that all the beneficiaries are to be treated as privy in interest to the beneficiary who raised the point. So that might be a solution to your knotty question.
I mean, it also raises a more philosophical question about a debate that's often had between common lawyers and civil lawyers about what is the purpose of an arbitration. Because you can see that in that situation, we all look at it through our common law eyes, with that type of will situation binding unborn beneficiaries and going to court to get it blessed, for example, to make sure that it's binding on non-parties. We have that view that ultimately a court or arbitration tribunal's perspective is to get to the truth, the right answer. And if you start from that perspective, there cannot then, you look at it that way, be a completely different reading of the same provision between two different parties to the same contract. Whereas if you look at it in a much more functional and practical way, as some of our civil colleagues do, or civil law colleagues, I should say, do, the purpose of resolving a particular dispute is specifically to resolve that dispute between those people on those facts. And therefore, the fact that there may be an inconsistent reading of the same provision in two disputes under the same contract between different parties, in a way, is less concerning, because if you had a better lawyer in one case than you had in the other, they might win, whereas they might lose in the other one, but that's fine. And I think it does raise questions, because we talked earlier about the fact that different people look at it differently based on their tradition and their learnings and their what they're familiar with. I think that's another factor I think that we need to bear in mind And your case sounded like it was really along those lines, Simon, when you were talking about your French arbitrator feeling uncomfortable with Swiss principles, and that's within the civil law tradition.
Yes, and I think the philosophy of saying, well, of course, we'll prevent relitigation of obviously relitigated matters, but we are here to resolve a dispute between the parties, is a helpful one. I mean, take another example, bifurcated hearing, gas contract again. The defence, long-term breach of supply. The supplier did not take a force majeure defence based on sanctions. It might have offered a defence to liability, it might not, but he didn't take it. Quantum stage. Supplier having gone down from non-supply of gas for 10 years. The supplier says, well, I rely upon sanctions and the fact that force majeure would have applied as a defence to your claim for substantial damages in the but-for scenario. Because in the but-for scenario, you could never have performed for 8 years because of sanctions. Argument by claimant, oh no, you can't rely upon sanctions. You should have relied upon sanctions at the liability stage. You can't now, and indeed the award on liability carries with it as a surjugé, to use a French term rather than a Latin one, the fact that the contract could have been performed by you and could have been performed by me because you're in breach. And that's really quite a knotty one. That's actually a point which is being decided at the moment. But that's really quite a knotty question, and it raises really complex questions of identity of subject matter. And as you know, you get involved in a case a long way down the line for a different stage, new counsel, new ideas, and how do you have to future-proof your quantum stage, the liability stage, by taking arguments to make sure they've been tabled? It's very difficult, very difficult.
I'm gonna say a couple of things here. One thing I should have said about half an hour ago to anybody who's participating, please do send your questions in via the Q&A function here, and we will pick them up. We'll pick them up at the end of the session. The other thing is we have had a Q&A, or a queue in the Q&A, and I will just encourage my colleagues, my panelists, to take a look at that so that we can come back to that. It probably requires a little bit of thought. We can come back to it.
I think that has chairperson question written all over it, actually, looking at it.
Yeah, I'm looking forward to coming back to this question. I will do that at the end, and I'll give you all an answer. But what I would like to do actually is talk about the privies point, Simon, that you raised a few minutes ago, but also the international law aspect, because that's another dimension perhaps altogether. And maybe, Jessica, I know a big part of your practice is in the investment treaty space. It's a big part of what you do. Do you see the same issues coming up there? I know the privies issue comes up, doesn't it, with shareholder claims and different cases being brought by different parties. But do you see the same issues coming up in the investment treaty space?
So yeah, on one view, the chances of the strict res judicata arising as between sort of investment treaty and commercial arbitration, it's not likely to arise as between the two, because there's no identity in the cause of action, and indeed there's a different legal order. So of course, more common is the issue of different claimants bringing claims on the same events. For example, the Lauder and CME cases against the Czech Republic under two different BITs, and then resulting in very different decisions. There can also be a commercial contract claim and a treaty claim arising against the state by an investor out of the same facts and circumstances. And in that scenario, there may be a strong practical case for res judicata to apply in some manner, perhaps to call findings of fact that have already been determined, albeit that the ultimate separate question to be determined is whether there's been a breach of the treaty as opposed to a breach of the contract. And while the two may follow in many circumstances, including where there's an umbrella clause that is effective in the treaty, the question clearly remains legally distinct and to be decided afresh.
Ed, have you seen that in your investment practice, especially that sort of parallel idea of contract and treaty disputes?
Yes, and this arises very, very frequently obviously it's most acute, as Jessica quite rightly pointed out, where you have a claim based on an umbrella clause in the treaty, because if in that situation you've had a finding under the contract that there's been no breach, it's very difficult, you would have thought, to escalate that to the level of a treaty claim in separate proceedings on the basis that there's been a breach of an obligation if there's been a finding by a properly constituted and properly seized tribunal of that issue. And that's been taken more widely. The Ampal American Israel Corp and Egypt case, they went slightly further, and there they were separate entities, and it wasn't an umbrella clause, I don't believe from memory, but the tribunal there held that the shareholders could not effectively be put in a better position than the underlying company. Now that's pretty controversial because, as Jessica says, need to be looked at completely afresh, and you should be looking at the treaty claim in its own order as completely substantively and jurisdictionally distinct. But where there are findings of fact that are completely relevant to the latter case, it's very hard to get away from that unless you can point to some form of irregularity or bias or denial of justice, which are all things that regularly come up in investment treaty cases, to explain why it's not a proper res judicata. And because here we're generally talking about principles of abuse of process. That seems to be the general basis upon which investment treaty tribunals bring in principles of res judicata. The other point, I just wanted to mention the RSM and Grenada case, because there they applied principles of res judicata to jurisdiction, which is, in my experience, less frequent. And there, effectively, the shareholders of RSM brought claims, and they were found by the tribunal to be bound by the decision that the entity in which they were shareholders did not have jurisdiction, and they were found to be privies such that they could not bring separate claims and benefit from that. So that's just an interesting anecdote I thought I'd bring up.
Another issue that crops up in investment arbitration is whether tribunals have authority to revisit preliminary rulings in the same proceedings. And in some cases, in most cases, it seems that it's held there's no authority to reconsider those, and effectively a res judicata has been achieved over decisions that were made before. And in Parenco, for example, the tribunal held that there was no power for the tribunal to revisit decisions in any event, and any complaint of procedural fairness would have to be brought in annulment proceedings, not back to the tribunal asking them to revisit a point that already decided in an earlier part of the arbitration. And ConocoPhillips versus Venezuela and Nico Resources versus Bangladesh Petroleum went the same way. All that said, there's always an exception, and in Standard Chartered Bank in Tanzania, the ICSID tribunal there held that it did have power to reopen and reverse an earlier decision on jurisdiction and liability. So there was no res judicata in that context. But I think that comes down to probably the very particular context, because the tribunal had found there'd been a deliberate and misleading withholding of material information from the tribunal at the time the first decision was made. So it's yet to be seen whether actually, without some exceptional quality like that being present in a case, whether tribunals would be prepared to reopen decisions, or whether it's even in earlier events in the same arbitration, that's enough. Res judicata is formed as soon as that decision is made. Well,
it's interesting, Jessica. I in one of the contexts that I've seen the res judicata question come up again, a gas price context, I'm afraid, but you had the odd scenario where there was a set-aside application being made for an award on the basis that the tribunal had failed to do what it said it would do via its interim awards, which had res judicata effect on everybody, the parties and the tribunal, of course. So there was a big debate about a very odd existential philosophical debate about what the tribunal itself must have meant in its first decision and how it's departed from that in its second decision, and then and why it should therefore be set aside. An odd scenario, but it certainly comes up. And in fact, that brings us to the idea of set aside. We've touched on it already, I think, but I guess, Simon, if I can go back to you, this is fertile ground for set aside decisions, isn't it? And challenging award.
It is interesting, and I think it depends on how many barrels of the gun you want to use. I mean, DSME and Songa was a good example, Section 69, because it was wrong. But if you're finding, if you're actually applying ordinary res judicata principles and are finding as a fact that the subject matter is the same, Section 69 is not really very promising. So Section 68 is always relied upon as well. And that's not very promising either, because I think Ed's been the only one who's won one recently, because they all just get thrown out by the commercial court like confetti. One area which hasn't been considered, which it's come up recently in a case I'm involved in, is whether you can run a Section 67 challenge, because the res judicata, it can be relied upon effectively as a matter going to jurisdiction. So Tribunal 2 is seized of a claim which the respondent contends falls within the scope of a decision by Tribunal 1. Tribunal 1's decision is conclusive and preclusive of the subject matter in Arbitration 2, and Tribunal in Arbitration 2 should decline jurisdiction over it. I think that's a bit of a stretch myself, because it seems to me that it's more a defence on the merits. It's not a matter that goes to the substantive jurisdiction of the tribunal, certainly not as defined in Section 30 of the 1996 Act, subject matter of the arbitration. And you take other examples. I mean, if you settle a point, however conclusively you settle it, that doesn't oust the jurisdiction of the arbitrators, DDT trucks. And if you actually make a concession in one arbitration that you won't take a claim, and then you do take it in the second arbitration, again, that doesn't get it, not a matter going to jurisdiction, see Clare and Thames Water. So I think you're left with two barrels only, Section 69 and Section 68. That would be my view. I don't know what the others would think.
No, I agree. And the other point I should make, and this goes back to applicable law, but many legal systems see questions of res judicata as being public matters of public policy. Right. And so it gives you not only an argument, as you've already highlighted, under Section 68 potentially, and Section 69 in the rare cases where that's not excluded anyway, but it may give you fertile grounds for resisting enforcement. And that is the context in which it comes up relatively frequently in state courts. So that's the only point I wanted to add on that.
Yeah, I agree with that.
And perhaps that while we're exploring creative options under the Arbitration Act, perhaps there's scope for a challenge to the tribunal before the courts under Section 24 as well. If the tribunal determines issues to be res judicata and a party disagrees with that ruling, the argument would be that the tribunal has refused to properly conduct the proceedings, and that would be based presumably on an allegation that they failed in their Section 33 duty to give each party a reasonable opportunity to put their case and deal with the case of their opponent. Yeah. Which again brings us back to Ed's discussion on the choice of law, which law decides these matters. Because if the courts of the seat think it's the law of the seat, then when you get to the point of challenge before the court, then for the tribunal to have chosen a different route, they're likely to come unstuck at that point.
Yeah,
I find it very interesting. We've had the Anchor and Chubb decision on the law applicable to an arbitration agreement. I personally think this is an area of law that could do with a little bit of judicial guidance as well. It'd be very interesting if any of these questions come up and make their way up through the courts of any particular system soon. Now,
it sounds like Simon's doing his best to get them up.
I'm trying.
Order.
Now we have some Q&A, which is fantastic. I'm going to try to go through those quickly in the time that we have. A couple of the questions relate to subsequent actions before a new tribunal in relation to issues that have been decided, considered and remedied, or could have been considered and remedied in an earlier arbitration, where there is no new or different loss compared to the first arbitration. And the question that comes from in this context is there's a Henderson and Henderson question here. and this duty to, whether or not there's a duty to concentrate claims in the first arbitration. So Simon, I'll do as you said, I'll try to give a view on that. I personally think that if there's no new loss that's been suffered, then it probably is incumbent on the parties to work out what it is that caused them to suffer the loss in the first place and what that cause of action was, and to try to articulate that in one and the same proceedings. But do any of you have a view on that? Simon, do you want to?
I agree with you. I mean, if you've suffered a loss of profit over 5 years, and you say that loss of profit is due to X, Y, Z, and you put that forward, and then you lose on that, and you think, oh, well, I'm now going to claim the same loss, but it's actually A and B were the causes, and new breaches, I think that would fall straight within any system or any system of laws understanding of what res judicata is really designed to get at, because otherwise you just have multiple reopenings when you think, okay, I lost that one, try again, and that would be wrong.
I agree with that. In that scenario, I think that's right. I suppose just on the broader Henderson point and whether the extent to which that should apply, I think there is an issue with the fact that the tribunal's duty is to try and resolve things as efficiently as possible, and if there are issues that are not key to the determination of the proceedings, I think that there may be cases where the fact that a party did not raise something it could have in theory raised that was related, that could have been discussed in an earlier time, if it was not raised because it was not necessary at that time, then I can see why that would be potentially a cause for a different outcome.
Yeah.
It also, it raises the practical point, which is one of the questions that we've got is, what's the best practice then to get around this Henderson and Henderson risk? Should you basically plead the kitchen sink, so to speak, to make sure that you don't leave any potential cause of action, factual matrix out of your pleading at the risk of losing the right to do so later? And I think, you need to strike, my view is that you need to strike the right balance, because you want to plead things that have some merit to them. Because if you plead things just for the sake of not losing the right to potentially plead them down the line, if things were to change, you can lose credibility on those parts of your claim that do have merit. So it's part of the judgment call that we all have to make when we're pleading cases across the board. I don't know.
Yeah, I agree with that. I don't really think that anybody really, when they're preparing for a case as claimant or as respondent, really wants to hold an argument back. They want to put all their best arguments, forward at the right time. I think this usually comes up when somebody, either there's a change of counsel team and someone says, why the hell didn't you take that point? or when you've lost something you weren't expecting to lose, and suddenly you can't accept the loss, and so you have to come up with some other way of putting it to try to relitigate it. I don't really think it's a problem of best practice. You want to look at your case in realistic terms and put forward all the arguments which you think are going to win. And if you've got an alternative argument, and a second alternative argument, and a third alternative argument, as we all know, we put them forward. If they're runners. If they're not runners, then we don't. So I'm not sure that's really a practical problem. I think when you are bifurcating, I think sometimes people need to give thought to what arguments should come up at the quantum stage. It's really a question of whether the arguments are even in play, whether you're actually defining the subject matter of the arbitration. And I think the tribunal can help on that sometimes.
Well, we have it. Speaking of tribunals and appointing tribunals, one of the questions that we have relates, I think, Jessica, to the point that you were referring to earlier about what the panel's thoughts are on appointing or objecting to the appointment of an arbitrator who is nominated in a new referral, having previously been part of a tribunal that decided similar issues under the same contract or parties or cause of action previously. So what should you do?
It's a really interesting one, because it can be pretty tricky to mount a viable challenge on the basis that an arbitrator has what could appear in any other's context to have the right expertise to decide a case because they've done something similar before, but it is a real issue. It's the issue estoppel point, the issue conflict. And I think there's a scenario potentially where if it is professionally impossible for an arbitrator to take a different position from one they've taken before. For example, I think it may arise more often if it's cases they've had to argue as counsel. I think it's perhaps that's where it may become more acute, where you've had to take a position for a client as counsel, and then you have to decide the same point afterwards, and you feel perhaps there's a conflict in between, which way you might do it, and whether you can really bring a fresh pair of eyes to an issue if you're coloured by it in a different context. And that could be the case. But really, whether if it's an arbitrator who's made a similar decision before and making a decision again, I mean, I don't think that there's scope really to object that's likely to get you very far, unless you can really show some evidence that it goes beyond this into sort of a real clear bias that will prejudice you in that particular case.
Yeah, unless the arbitrator is ill-advised enough to speak about the case at the point afterwards. And we had a challenge in Chambers to an arbitrator who decided to point a particular way, but then gave a talk about why that way must have been right. And he resisted standing down, but he was challenged and he was booted out.
I think, this is an issue that we see a lot in investment treaty cases because of the public nature of the decisions. And a couple of things. Firstly, there have been a large number of challenges to arbitrators on this basis, and most of them have failed. Plus, there were the two very infamous cases back in the early 2000s relating to Argentina. I won't name the arbitrator, but this particular individual was on two tribunals that came to completely both unanimous opposing views as to whether there was a state of necessity in Argentina at the time, which caused huge concern and really led the call, which I think is pretty widely accepted as being best practice now, that you can't really, in investment treaty cases, act as counsel and sit as arbitrator because of this issue. If you're part of a panel that makes a decision about what necessity is in a particular scenario, it's impossible for you to be counsel arguing the opposite, and even relying on your own decisions is highly unattractive. So I think there's been quite a big move. The other quick point I want to make, I'm conscious of time, Gaurav, is this has come up quite frequently in investment treaty cases where you have parallel arbitrations under the contract on the one hand and under the treaty, and one of the parties thinks it would be a good idea to nominate the same arbitrator in both, and that creates serious issues and raises very significant difficulties, and there I've seen it very successfully opposed, probably correctly.
Okay, there's an interesting point that's made here. We are close to the end, but there is time for one more question, and it's about, Simon, earlier you spoke about res judicata issues arising within the same arbitration between the same parties in the same tribunal. But instead of taking a res judicata point, might the party opposing the res judicata argue that the tribunal's authority is spent in respect of the issue, i.e. functus officio? So that's an interesting question about mandate. Has it come to an end? Have they got any basis at all, even if they wanted to address the question again, or is their task over for that part of the dispute? Does anybody want to have a go at that?
I don't think it can be over for I've dealt with your claim for a breach of the gas contract between January and December. Therefore, I can't go back over it again. I don't think it's a functus point. I think it does raise a res judicata point because we've decided that, and now you're reopening that particular issue. But then that would require the subject matter to be investigated. And if the subject matter is slightly different, sufficiently different, then why shouldn't the arbitrators have a second crack at it in a different context? So I don't see it as a functus issue, just like it's not really a jurisdiction issue, I think.
Mm.
I'm seeing my colleagues nodding with me, which is very, very comforting. We did all agree we would always.
Nodding wisely.
That's great. Look, I don't want to spoil that in that case, while we're all in agreement. So that probably seems like a very good place to stop, I would say. So all that remains for me to do is to thank the panelists for their participation. We're incredibly grateful. What a wonderful discussion we've had. Thank you all. And thank you all for participating. Great questions. I'm sorry we couldn't answer more, but thank you all for tuning in. And we look forward to seeing you again next year. Stay safe, stay well, and enjoy the rest of your week.
Thanks, everyone. Thanks. Bye.
Thanks all. Bye.